Okay, good afternoon, everybody, both here in Minneapolis and also on the webinar. My name is Joe Liniak, and I'm one of the bank regulatory people here at Dorsey & Whitney, and want to welcome you here. We're going to be talking about recent federal developments in consumer law, and this is going to be kind of a fun topic for nerds out there. Because we're going to be talking about a bunch of nerdy subjects, and we've got a bunch of nerds up here. We've got Aaron Bryant, who is one of the few people capable of being able to recite the Federal Reserve Board's commentary backwards. And then we've also got Steve Wells, who is a real appellate litigator who has litigated in the Supreme Court. And we're going to talk about, again, a really interesting topic at the end, which is whether or not the CFPB is constitutional or whether or not we can ask for the $12 billion back that they collected over the last 6 or 7 years. We're going to start out by talking a little bit about the history of the CFPB and its evolution, to do a catch-up, talk about the current administration of Director Kraninger. Aaron is going to talk about current CFPB regulation and how that has evolved over time. I'm going to discuss their enforcement activities since Director Kraninger took over, and then we'll get to the constitutionality issue, which again is just kind of a fun topic. We can go back and remember first-year constitutional law and what it all means, but it really does involve the executive branch. A brief history, and as you know, the CFPB was created by the DoddFrank Act in 2010, and all of the lefty Democrats were screaming about the fact that this was going to be the new sheriff in town, and we were going to correct all the difficulties in the consumer arena, led at that point and created by what became effectively Senator Warren, where she was the person standing up the CFPB. In the act itself, in Dodd-Frank, very, very significant powers were given to a single director, and that becomes important because we're going to talk about the constitutional issues a little bit down the line. The Congress, in its infinite wisdom, from the Federal Reserve Board, transferred practically all federal consumer laws to the CFPB, and since I guess they like dictatorships, decided to give the sole power to amend or interpret consumer laws to the single director, which was created. They also decided that they were concerned about what's called regulatory capture, and what they did was they made sure that neither the executive branch nor Congress would be able to interfere with the CFPB's operations. And they did that in a couple of ways. First of all, they utilized the theory of an independent agency, which again, Steve is going to get into a bit, but they specified that the only way that the director could be fired would be for cause, as opposed to the president wakes up one day, doesn't like you, or as a new president says, get out of here. Also, what they did is they took the funding component away from Congress and made the CFPB, it's actually a bureau of the Federal Reserve Board, and turned over the CFPB, the funding authority, by a percentage of the Federal Reserve Board's annual income. So Congress had no authority and has no authority to be able to regulate the CFPB in a manner similar to what they've done in the past with the FTC by cutting the budget. And then Director Cordray appeared. He was a recess appointment that President Obama put in because the Republicans did not like him a lot along the way. And actually that created a firestorm in DC, and his appointment was eventually invalidated. In fact, as you probably know, when it comes to the CFPB, just about anything they do is going to be objectionable by somebody. And ultimately, though, there was a compromise, and Director Cordray was confirmed by the Senate in 2013. he immediately adopted an extremely pro-consumer, anti-industry supervision and investment strategy. And a number of the things were done which, frankly, of definite concern to industry members, particularly banks that I think legitimately thought that they were being targeted because they're not as nimble as a lot of smaller companies that can appear and disappear at will. Among other things that happened is that the examiners were encouraged to examine banks, and the CFPB had direct examination authority for any bank over $10 billion in assets. They also had indirect authority to be able to sit in for smaller banks, but the direct examination authority was particularly burdensome for banks over the $10 billion mark. They also embedded attorneys in the examination process. And then after the examination would be over, they would bring the examination reports back to DC, and it'd be a second scrubbing of the examination conclusions to see whether or not the examination staff wanted to take enforcement action, notwithstanding the recommendations of the actual examiners. So really, there were several different layers of very, very significant enforcement that took place. And what they did is that they emphasized high visibility enforcement actions with very, very significant penalties. And then there was Director Cordray finally resigned in November of 2017. And for many of us, we had the going away party the day after he left. The president appointed Mick Mulvaney, who was head of OMB, to be the acting director of the CFPB, which again created some controversy. The assistant to Director Mulvaney filed suit alleging that she should have been the acting director because of the appointments powers and several different succession statutes in federal law. And Director Mulvaney took control of the CFPB, and the first thing he announced was the end of regulation by enforcement, which was probably something that everyone really enjoyed hearing because you may be aware of the PHH case, which we're going to discuss in a little bit. But other things which he did, which were a little bit quirky, was that he didn't like the name CFPB because I guess the prior regime did it. And so he decided to rename it the BCFP, which to this day people can't pronounce quickly. And he did that. And as you can see here, this is the, I've got the logo down of what the new logo was because he just decided to do it, which was really a shot across the bow that things were going to be different under his watch. He also indicated the fact that they were taking a different perspective in terms of interpretations of the CFPB's authority. And you may know that several different categories when the CFPB was stood up, they were exempt, such as, for example, auto dealers, and the CFPB had been going after them as well. And so he announced the fact that we are going to slow this down and really take a conservative approach as to who we go after. He also installed, and this is not unusual, political operatives in the operating divisions of the CFPB. And again, that's just not unusual to have that occur, but because of the fact that you had, I would say, probably a somewhat liberal staff, which was created by Director Cordray, again, created a lot of consternation in terms of the way that suddenly people were reviewing their actions from an entirely different policy perspective. And then Director Kraninger came in. She was nominated as director and confirmed by the Senate in December of last year. She's just about completing her one-year anniversary. She is a career civil servant in Washington, D.C., worked for Director Mulvaney at OMB, and has proven time and time again that she has virtually no identifiable consumer knowledge. And I say that with all due respect. I read Discover magazine every month, but that doesn't make me a nuclear scientist. And you really do need to have a real foundation in consumer law if you're going to be probably the most important person in our gross domestic product, which is 70% to consumer operations in the United States. And I think that this issue is going to continue to come up. Far less confrontational than Director Mulvaney, and she reverted the name to the name CFPB. And by the way, if you go back to the Enabling Act, there is a reference to the CFPB as the CFPB. So it's legal to call it that. It's also legal to call it that as a nickname. And you can see their new logo here, which is supposedly the light shining out to consumerism, which Director Kraninger has been using very frequently. Unfortunately, it looks like there's a problem with your computer screen when you actually look at it closely, but that's neither here nor there. That's her attempt to do something nice. Here is a real quick summary of how she has reorganized the CFPB. The CFPB has been reorganized innumerable times. Among what Mulvaney did is he tried to emasculate the fair lending operations. It's now been combined several different ways, and you can actually go on the internet and find about 20 different organizational charts of the CFPB. What will happen next week, who really knows, but she's certainly been consolidating her office in a manner that indicates the fact that she's really taking control. And I think the reality is that she really has been taking control and is becoming more of an independent entity as opposed to being one of Mulvaney's acolytes. The CFPB has got very, very broad authority. It's got broad authority over consumer financial products and services, and as I mentioned, it's got rulemaking authority. It's got rulemaking authority to do practically anything they want with the federal consumer laws. They have, my microphone fell off. If you recall, they have issued tens of thousands of pages of proposed regulations, and the joke used to be going around that the over and under for a new regulation was about 700 pages. Also, just about in all cases, written by a committee, so that every other paragraph really didn't make a whole bunch of sense because every committee member had to get a paragraph in there. Micromanaging a lot of regulations, with the exception of maybe the TRID regulation, not very helpful. What Mulvaney did in his tenure is he invited a review of all regulations issued by the CFPB. And the Washington establishment was all too happy to be able to do that and to respond, and actually inundated the CFPB with suggestions as to how they can improve things, such as telling us what the law is as opposed to hiding it from us, publishing regulations on a regular basis before they went about doing enforcement actions, and so forth. To date, very, very few of those suggestions and the review process have been implemented by the CFPB, either by Director Mulvaney or Croninger. Supervisory authority, as I mentioned, they've got supervisory authority over just about all non-bank consumer financial institutions other than auto dealers. For banks over $10 billion, and anytime they want to insinuate themselves into an examination, they can. There's been a decided reduction in the enforcement scheme. I think certainly on the part of banks, which is probably helpful for this group, and we'll take a look at some of their enforcement actions in a little bit. They have also got some pretty unique enforcement authority. They've got the ability to enforce their consumer protection laws not only by administrative enforcement actions, but also by bringing civil suits in federal court, including appellate courts up to, but not including, the U.S. Supreme Court. And that means that they've been able to sidestep the requirement of going to the Department of Justice, which was used very, very frequently by Director Mulvaney, by Director Cordray, to a lesser extent by Mulvaney and Croninger, and yet still those challenges continue to happen, and they've got an active litigation staff. Before I turn it over to Erin, their rulemaking authority is APA, Administrative Procedure Act. The SBREFA limitation was put in by the Republicans, and it actually has been very, very helpful to us in that they have to do an economic analysis when they issue a significant regulation to indicate what the impact will be on smaller size institutions. That is always a great document to get your hands on, because the way that they utilize it, they say, well, if our proposal does not work, here are a number of alternatives that may address an issue for a small size institution, which lays out secondary and tertiary level priorities that may come up in case there's a giant public outcry. They've also got the ability under FSOC where FSOC can override a CFPB determination, and that's going to happen, I think, when the rest of the polar ice cap melts. So it's really a nothing burger, but it still is out there if they do something. In today's world, you can't say truly crazy because you can't even imagine what truly crazy means. And now we're going to talk about CFPB regulations and where we stand at the moment. And Erin, take it away.
Great. This is Erin Bryan, and I'm going to be speaking about recent CFPB regulatory developments. So the CFPB announced its 2019 to 2020 regulatory agenda in May of this past year, so we're about halfway through. And overall, by historic measures, this was a fairly modest agenda compared to previous years, and it signaled a continuation of initiatives that were already in process at the time that Director Kraninger was appointed. As Joe alluded to, and many of you will recall, in 2017, President Trump issued an executive order requiring that for every new government regulation to be identified for elimination. And then last year, the Department of Treasury released a special report titled Regulatory Reform Accomplishments under President Trump's Executive Orders, which contributed to similar pressure. Also last year, the Implementation of Economic Growth, Regulatory Relief, and Consumer Protection Act was enacted. And among other things, that law was aimed at reducing regulatory burden on community banks. So there's a lot of pressure on Director Kraninger to proceed cautiously with new regulations and also to find opportunities to review the burden of existing regulations. And in general, I think the regulatory agenda reflects those pressures. So today I had planned to discuss the 3 rules that are in bold on this slide. But hot off the presses, as most of you have probably seen, the CFPB today published a request for information on the TRID rule, so I just want to briefly mention that. TRID, of course, is short for the Truth in Lending Act and Real Estate Settlement Procedures Act Integrated Disclosures. And this request for information is not a formal step in the rulemaking process, but the announcement does send a signal that the CFPB is open to considering whether to modify, expand, or even eliminate the TRID rule. Specifically, the Bureau is planning to address the TRID rule's effectiveness in meeting its own specific goals, as well as the purposes and objectives of Title X of DoddFrank. All right, so the first regulation that I want to talk about is the payday lending rule, which we've all been talking about for quite a while now. The CFPB first issued a proposed rule on payday vehicle title, thank you, and certain high-cost installment loans in 2016. And the rule has been dogged by controversy from the start. 2 trade groups representing payday lenders sued the CFPB to invalidate the rule, claiming that it was arbitrary, capricious, and unsupported by substantial evidence in violation of the APA. Then when Mick Mulvaney assumed control of the CFPB, one of his first actions was to announce reconsideration of the payday lending rule and an intent to delay implementation. Consumer advocates were very quick to point out that Mulvaney had previously lobbied for payday lenders and received contributions from them. The most recent development here was that in June of this year, the CFPB issued a final rule to delay the compliance date for the mandatory underwriting provisions of the final payday lending rule from August 19th, 2019 out over a year to November 19th, 2020. And the stated reason for the delay is that the Bureau said that it was going to allow them time to review comments on the mandatory underwriting provisions and consider changes, and it's very likely that changes will be forthcoming. And
One thing, Erin, that I think bears mentioning here, and it's one of the things that when you read over the information of the research that the CFPB did in regard to the payday rule, is that they embedded in it an obligation of showing the ability to repay for people borrowing from a payday lender. But the problem is you are at a payday lenders because you have no ability to repay, because you've created a situation economically where you probably have got bad credit, you probably maxed out your credit card accounts, you need $500 to fix your car. The demographics of who uses payday lenders are people in the category where about 40% of the United States, they do not have $500 to be able to handle a short-term emergency, and there's no place to go. And if you have basically hurt your credit, you've got no choice but to go to a payday lender. And this is one of those really intractable problems that people need to deal with, that it may not necessarily be a good industry, but we need the industry because we have got a large segment of our population that needs to go somewhere. And maybe it's a personal choice that I am willing to put up with a longer-term financial problem in order to solve a current financial problem, such as fixing my car so I can get to my job. And I think that that's really one of those things that is circling around here that we, from a policy position, need to look at as this payday lending rule is reevaluated and hopefully can be corrected.
thank you. Yes, I agree with that. So I've included the CFPB's summary of the June 19 delay final rule, and I'm not going to walk through these, but they are there for your reference. So I just wanted to point that out. Next, I'm going to talk about the debt collection rule, which this year has probably received the most attention. This is a very new rule with an incredibly deep history. The Fair Debt Collection Practices Act was effective in 1978, and it was intended to eliminate abusive, deceptive, and unfair debt collection practices, to protect reputable debt collectors from unfair competition, and to encourage consistent state action to protect consumers from abuses in debt collection. The credit industry has had decades of experience with the law. And although there was consensus that the law was not up to the task of dealing with modern forms of communication, I'm not sure that anyone was really expecting the CFPB to issue such an extensive set of rules that would revise most aspects of the law. But in May of 2019, the CFPB issued a proposed rule to implement the Fair Debt Collection Practices Act. And it immediately generated a ton of interest from creditors and consumer advocates alike. The comment period was extended but closed in September, and more than 12,000 comments were received. So what does the rule change? The primary intent was to modernize the regulation of debt collection to account for electronic and text communications. However, the proposed rule is fairly wide-reaching. It includes changes to the definition of debt collector, consumer, and debt, which have been fairly controversial, provisions for electric communication safe harbors, consumer options to unsubscribe, communication medium, time, place, content, and frequency restrictions, prohibitions against collecting time-barred debt, and against debt parking, which is essentially where you report a debt on a credit report, but don't take any actions to notify the consumer or enforce it. So surprise, when you pull your credit report or apply for credit, it's there. Also restrictions on transfers of debt and requirements for disclosures and validation notices, including a model form. So I'm going to go over some of the comments that were received to this because I think that they're pretty illuminating for the content of the rule. The FTC submitted a comment saying that they supported the proposed rule probably 20 times over. We support this provision, we support this provision. But their letter primarily seemed aimed at reminding the Bureau and the general public of the history of their enforcement of debt collection protections and their ongoing commitment to protecting consumers. So it was not a lot of substance. The Small Business Administration took issue with the Bureau's failure to include sufficient support for its flexibility analysis and exclusion of findings on cost of implementation. It also expressed concern that the Bureau's inclusion of UDAP provisions, which are unfair, deceptive, and abusive acts provisions, would create uncertainty and legal risk for first-party creditors, meaning the initial party that's extended the credit. A group of Democratic senators also submitted a letter that criticized the CFPB for not going far enough to protect consumers. So already you can tell nobody was really thrilled with the final proposal. A number of creditors groups submitted comments as well, and I'll mention two of the most comprehensive letters. First, the Association of Credit and Collection Professionals, or ACA International, submitted a 154-page letter telling the CFPB that it agreed with everything. I'm just kidding. They disagreed with everything that was recommended. It outlined concerns with almost every aspect of the rule in great detail, including taking issue with restrictions on the time, place, frequency of calls, saying it would increase costs, and that the restrictions would increase the length of time that it takes to resolve a debt, as well as increase litigation and ultimately harm consumers. They also pointed out that in their view, consumers increasingly prefer modern forms of communication like text messaging and emails, but that the Bureau's proposed electronic flowchart for electronic disclosures is so complex that it would make it impossible for debt collectors to actually use it and send communications by electronic methods. They also said that the e-sign consent forms and email are unnecessarily complicated, and that the uniform validation notice that's included with this creates ambiguities regarding itemization. The Consumer Relations Consortium essentially agreed with most of what was in the ACA International letter, but they also proposed a few changes to the rule, including suggesting that the CFPB add a safe harbor for reasonable processing times for consumer requests, add a creditor right to cure that mirrors California's Rosenthal Fair Debt Collection Practices Act, and changes to the form of validation notice that would add greater flexibility for formatting and alternate text blocks that could be used. So predictably, consumer groups were very happy to see renewed attention to debt collection and appreciated the consumer-oriented changes, but they generally felt that this was a gift to the credit and collection industries. I think that the credit and collection industries would strongly dispute that characterization, but again, the point being that nobody was particularly happy with the outcome. One of the more significant comment letters from a consumer group urged the CFPB to strengthen consumer protections, including by imposing stricter limits on telephone calls. One of the criticisms is that this would theoretically allow more contacts with debtors. To clarify that consumers can simply say, stop calling in order to stop communications, and prohibit messages left with employers or other third parties. They also proposed eliminating safe harbor for collection attorneys who make false, deceptive, or misleading representations, which is always subject to litigation and in the eye of the beholder, and require them to review original account documents before filing lawsuits, among others. All right.
Well, you know, one of the things to note, which is actually one of the real quandaries I've never been able to figure out about the CFPB, is that up until the DoddFrank Act, the debt collection industry, probably very smartly, prohibited the FTC from issuing regulations regulating fair debt collection practices, very similar to the prohibition that, under the Fair Credit Reporting Act, where there was no federal agency to issue official regulations to interpret it, which gave them the opportunity to drive several Mack trucks through the language and to do things, and you ended up with the federal courts giving interpretations which, if nothing else, this may resolve a lot of the federal court problems where in one in one district, you leave a message saying, please call me back, I'm a debt collector. And in the other, it's a similar violation if you don't identify who you are when you're doing debt collection. So that's probably a good start. The quandary here is, why did the CFPB wait for 8 years in order to do this? This is the #1 consumer complaint in the United States getting done by debt collectors, and they simply refused to do it under Cordray. And I mean, it's one of those questions which I think will probably never be answered, but they did not do so. And another point which may eventually come out, debt collection companies are really, really small. And when you read over the literature that the CFPB did when it was doing one of its research projects, debt collection companies, there's not that many large ones at all. There's a lot of mom and pop companies, and one of the problems you have in terms of doing enforcement action is they disappear and reappear across the street with a different name, doing the exact same things, transferring the sale of the debt or the contracts for the debt. Very, very hard to track these folks down and make sure that they do a proper job. So again, there's really some significant tasks ahead of the CFPB to do this properly, but harmonizing decisions in several of the judicial districts, I think, would be a good start.
Mm-hmm. And I think the Small Business Administration's letter was certainly written with those groups in mind. One final comment on that rule before I move on, which is, it's difficult to predict what's going to happen next. As I mentioned, no groups were particularly happy with the final text. So whether they're going to come back with a final proposed rule or go back to the drawing board or just put this on pause for a while, it's really hard to say, but certainly something to watch. All right, the last regulatory development I'm going to talk about is the CFPB's, lack of action so far on the QM patch. So as background, the CFPB's existing ability to repay rule requires mortgage lenders to verify a borrower's ability to repay their mortgage during the underwriting process. And this includes making a reasonable, good faith determination of a consumer's ability to repay. It also requires that the borrower's debt to income ratio not exceed 43%. So the so-called qualified mortgage or QM patch exempts GSE-backed loans from complying with the full underwriting standards of the ability to repay rule. And because that's such a significant portion of the loans that are issued in this country, that's a very sizable group. So Fannie and Freddie loans, all of which are qualified mortgages, have not been subject to these debt-to-income requirements since 2014. The problem is that the QM patch is set to expire no later than January 10th, 2021, and the industry doesn't know yet what, if anything, will be replacing it. The Bureau is planning to allow the temporary QM patch to expire, but is considering a short extension, if necessary, to facilitate a smooth and orderly transition, in their words, away from the GSE QM loan category. And the Bureau is also considering whether to propose revisions to Regulation Z's general QM definition in light of that upcoming expiration, and has issued an advance notice of proposed rulemaking to request information about possible revisions. This is something Joe Liniak and I have been following for a while because it has the potential to cause huge disruptions in the mortgage market. And Joe, I don't know if you wanted to say anything else about that.
Other than the fact that this is a crazy proposal, no, it's a great job on the part of the CFPB. This is really stupid, and this is something that the industry has got to be very, very careful of. It was put in because, as you know, the way that it works, if you run a mortgage loan through either the two GSE's underwriting engines, you get an automatic safe harbor if the loan is eligible for purchase by one of the GSEs. You do not have to sell it to them. You get to keep it, you can sell it, you can put it in your own portfolio, but what you have is good housekeeping, stamp of approval. This is a QM, it's not subject to challenge. And what is happening now, and if you read the issuance on the part of the CFPB, they say in one paragraph, we're simply not going to renew it. And at the end, they said, well, maybe we will, but they really don't like it. Mulvaney did not like it. Croninger does not like it. And one of the very, very large mortgage trade associations hates the GSEs. And so getting rid of it is not a good idea, or is a great idea on their part as well. But what it does is it potentially exposes the industry to what comes next in terms of an underwriting engine. And the underwriting engine has got to be able to verify that you considered the ability of a borrower to repay the loan. Now we have an automatic safe harbor once you run it through one of the underwriting engines. What comes down the line, what's going to replace it, what type of work you're going to have to do in order to be able to come up with your own underwriting approach that has to be certified or verifiable is anyone's guess. I suspect that as time goes on, before we run out, there may be a move on the part of the industry to say, put something else in its place, but let us continue to use the underwriting engine because it's easy to do. It is part and parcel of everyone's process. And replacing it could really cause disruption to the origination system for residential mortgages in the United States. Other than that, it's a great idea.
All right, I'll give that back to you.
Okay, we're going to talk a little bit about CFPB Enforcement Authority. And as we alluded to earlier, the Enforcement Authority is very, very broad, starting out with something similar to what the FTC has, which is their ability to issue civil investigative demands or CIDs. And that goes to the idea that we want to find out what's out there in the marketplace. Are you doing something wrong? Is there a particular problem? Has someone targeted you? And we can ask you a broad set of questions. We can ask for your deposition. We can ask for interrogatories. And they've also got the ability, as has been mentioned, to allege UDAP, unfair deceptive acts and practices. It doesn't have to be illegal. It simply has to be unfair, which has been for the last 8 years, a very, very difficult standard because they've been unwilling to tell us what that really means. And in the case of banks, looking at bank practices and immediately saying, we don't care if it's preempted, it's a UDAP. At that point, you're off to the races. Also, in terms of civil money penalties, they have got parallel civil money penalty authority compared to Section 8 of the Federal Deposit Insurance Act in terms of imposing civil money penalties, as well as very considerable restitutional authority and other remedial actions which they can take. And certainly in the case of the Cordray administration, they were very, very aggressive in terms of doing that. Recently, the White House issued a number of executive orders which I think will be very, very helpful to the industry and actually to government in general. It talks about agency guidance and agency enforcement. And what they say is, you've got to tell us what your policy is. You know, what a revolutionary idea that is in terms of transparency. Agencies have been instructed to look at policy, to publish policy, and to finalize regulations indicating how they would establish policy. So that's a really good start because you don't want people to be taking enforcement actions where all we really want to do is comply. We may not like it, but we will comply, but we have to know what it is. And the other part, which is something that the industry has struggled with, is that the executive order indicated that an agency may not use guidance documents to impose new standards of conduct. So you can't just turn around and say, abracadabra, we've now got a different perspective. It really requires them to go through an APA type of process to announce the fact that we are reconsidering or reinterpreting statutes before they can go about to do that, and they've got to publish guidelines as to what that means. And this is very, very helpful to us in terms of how the process will work. You may be aware of the kerfuffle regarding PHH and the RESPA issue. If these guidelines have been imposed prior to the CFPB taking the enforcement action against PHH might still be around here, but because, and we can go into that a little bit later. We've got here a number of Oh, well, one thing before I go on, the CFPB also issued a announcement that they were changing their CID policy, and they were going to be a kinder, gentler CID policy. And Director Kraninger indicated the fact that they would have more information in terms of what's in the CID, why they were going after you, what the potential violations would be. And for those of you that have seen recent CIDs, it's kind of questionable whether or not they're following it. We tried before this session to get a hold of what the new policy is, and it appears that the policy may not exist other than the fact that Kraninger made an announcement and issued a press release. There does not seem to be any external documents. We're going to file, just for informational purposes, an FOIA to see whether or not anything was circulated. But right now, there is no document out available to the public talking about the kinder, gentler CID policy, which is probably, again, not a particularly good way to run a governmental agency. We've now got here several enforcement actions which we have listed for the last year. And we're not going to go through all of them, even though, of course, they're terribly interesting. Actually, they're not terribly interesting. They're not very large. They're not, in most cases, not very egregious, dealing with things that you would think a consumer enforcement agency would want to be enforcing. Some of them are leftovers from at the end of Cordray's tenure. Some of them are working their way through the system. One of the things interesting is that the civil money penalties are not that high in many cases. Bad guys who they took an enforcement action against pled poverty and had a $1 civil money penalty assessed against that person. An interesting and different approach. And again, some of these ones are one-off, but what's notable about them is that when you read through them, you say, wait a minute, this is really not regulation by enforcement. It's a different perspective. And they're available on the website. The CFPB has issued them, and you can read them if you want. One of the things which is kind of interesting, though, is there are enforcement penalties collected over the years. The enforcement penalties have more or less evened out between the last 3 years and the first 3 years of the CFPB's tenure. This is money that was actually collected by the CFPB. There's an ongoing issue as to where the rest of the money has gone and who it's gone to. But this was the CFPB's report to Congress. And so there was a definite spike during at the later years of Director Cordray's tenure. And then it has definitely leveled off after that. Another interesting aspect, this is CFPB's enforcement cases, and when you average them out, they average out at about a little less than 30 a year, and clearly when Director Mulvaney was in charge, they went down to a very, very low level. They're now up to about 21, probably increasing. There's a lot of scuttlebutt around that they are now actively investigating, possibly not with the same emphasis on high-level, high-profile enforcement actions, but still doing investigations. I would not be surprised if we ended up coming back to the 30 or so enforcement levels, which means that the CFPB, to some extent, is back in business, and the enforcement staff is doing its job. This is probably the most entertaining of all the charts to show that between 2012 and 2017, they collected almost $12 billion in civil money penalties. It kind of went from there to a very small amount under Director Mulvaney. And over on the right-hand side, it came out with such a small amount that the PowerPoint couldn't even put in a small line down to zero, meaning that they have radically changed around what they're doing in terms of imposing civil money penalties, which is certainly good for the banking industry because, as you know, we're quite different from a lot of other folks in that you pay a civil money penalty, that comes out of your capital account. Does that really help us or hurt us? Is there a way of being able to say, fix this, which is really what the attitude is on the part of the banking regulators? They clearly have not been targeting banks the same degree that they were under Cordray's administration. So this is clearly a good result, and we would encourage them to keep up the absence of imposing penalties on the banks. Now we're going to come to the fun part of the presentation, where Steve is going to address an interesting constitutional issue, whether or not the CFPB and possibly a few other agencies are structured properly and are constitutional. Steve.
You know, when the Supreme Court takes on a case where it investigates the scope of the agency's authority or the jurisdiction for the authority, there's the usual kind of parsing of the authorization statute. They look to legislative intent. Kind of interesting, but not really much. That's not this case. So this case challenges the constitutionality of an independent commission in which there is a sole director who has all the authority to enforce and regulate 19 different consumer statutes. And the argument is that, first off, the case is Celo Law versus CFPB. The facts of the case are totally uninteresting. It's the issue that it raises that's really fascinating. And the argument that's being made here is that a director with a 5-year term who can only be removed by the president for, quote, inefficiency, neglect, or malfeasance in the performance of his duties. That is for cause, that where it's headed by just one person like that violates the Constitution's separation of powers doctrine, found in Article 2 of the Constitution. Now, this, as some of the lower court decisions have recognized, this case has the possibility of essentially remaking modern government as we know it. Because this, although a lot of agencies, independent commissions, independent agencies aren't run by one director, it's not entirely clear that this case will turn on this sort of one director criticism of it. So for example, the FTC has language that is, it's run by a commission obviously, and its members can be removed for exactly the same things that the director of the CFPB can be removed for. As the SEC, the Independent Counsel's Office, a variety of other so-called independent agencies, all of which could be potentially affected by this case. So let me just start. We only have a few minutes left, so I won't go totally nerdy on you. Let me give you a little bit of the history of this, and I mean just enough to whet your appetite. The Constitution actually doesn't address whether or not the executive, the president, has the power to remove members, either officers or employees of the executive branch. Doesn't say it specifically. Here's what it says. This is Section 1 of Article 2 of the Constitution. The executive power shall be vested in a president of the United States of America. Section 3 says, the president shall take care that the laws be faithfully executed. That's it. Those are basically the explicit powers that the president has to sort of govern his own fiefdom, which is the executive branch, obviously. In 1929, there was a case that settled the issue about whether the president has the power to remove employees or appointees in a case called Myers. But very shortly after that, there was a challenge to the constitutionality of the Federal Trade Commission. The Federal Trade Commission has several members, and it did in 1935 when it was first created. And all of those commissioners, too, may be removed for malfeasance, neglect, or inefficiency. Same language that's used in the CFPB statute. In the case called Humphreys Executor versus United States, again, facts not terribly interesting, just the result. The Supreme Court essentially validated this form of independence and said that these restrictions on the president's right to remove members of the executive branch, employees of the executive branch, are valid. And it looked at essentially two factors. it looked at whether what it said were the means of removal. And it said that this particular language, where the president can't remove for a cause that consists of inefficiency, neglect, malfeasance, that's okay, because the president still maintains an ability to control. It's not at will, so there are restrictions. But that means of restricting the president's authority is okay. When you look at the second issue, the second prong, and that is whether the agency is fulfilling some sort of a core executive function. And here the court said it's not. The FTC is performing issues or regulating matters that are quasi-legislative. It referred to it as kind of a quasi-legislative body involving financial affairs. And it held that this kind of an independence in this kind of agency is okay. And ever since Humphreys Estate was decided, there have been a number of challenges to other independent commissions. The SEC, most recently the Office of the Special Counsel. So in a case involving the Office of Special Counsel, this was in 1988, there was a challenge essentially on the same basis. There were restrictions on the president's ability to remove the special counsel. And the court said those are valid, relying essentially on Humphreys Estate, saying that basically this was just kind of policing employment policies in the executive branch, and that it didn't offend sort of this core principle of separation. Virtually every time that an independent agency's constitutionality has been challenged, up until very recently, it has been affirmed on the basis of Humphreys' executor. The one exception was the PFAOB very recently, in which the court held that, remember, the first prong is, do the means interfere with the president's authority and create a problem under separation of powers? And because the restrictions on the power of the president to remove the members of the PFAOB were more than just malfeasance, neglect, inefficiency, but actually involved willful misconduct and various other things that created a much more restrictive atmosphere for the president to remove. The Supreme Court said you've gone too far, and we're not going to allow those restrictions on the president's right to remove. So now comes this particular case. And it comes to the court based on really two recent cases. One is the PHH case, which you probably know about and Joe has alluded to. And that is a DC Circuit en banc case decided very recently, in which, en banc anyway, the court held that the CFPB's structure was constitutional, based again on Humphreys Estate and Morrison case, which affirmed the special counsel office structure. But there were a number of dissents in that case. And the most important dissent was an 80-pager by then Judge Kavanaugh, who held that he referred to the director position at the CFPB as the president of consumer finance, because the president of consumer finance really answered to nobody. Unless they committed some sort of really, really egregious misconduct. Not really beholden to Congress because of the funding mechanism, and not beholden to the president because of the very broad restriction on the power's right to remove him. And Justice Kavanaugh now Justice Kavanaugh, then judge, wrote a very sort of eloquent disposition on how this affects liberty interests. And his liberty interest discussion is certainly broad enough to swallow a lot of precedent that, including Humphreys' Estate, that might cause a sea change in the law if it's adopted by the court here. So when Celo has been accepted, as I said, on October 18th. Interestingly, maybe not surprisingly, the government sided with the petitioner. Both the government and the petitioner agree that the CFPB structure is unconstitutional and violates the separation of powers. And this happens it's not unique, but it's very unusual the court invites a lawyer to argue on behalf of the CFPB. So it has invited Paul Clement, who is a very accomplished, you probably heard his name, very accomplished Supreme Court litigator, but who often argues on the side of business interests. So we don't know what the CFPB's arguments are going to be. We know what the petitioner's arguments and the government's arguments are going to be because the cert petition basically quotes verbatim Kavanaugh's dissent in the PHH case. And so those arguments are pretty well set in stone. But we don't actually know what the CFPB side, represented by Paul Clement, is going to argue. It's likely that it will be based on the DC Circuit's majority opinion in the PHH case, which, as I said, was based primarily on Humphreys Executor and the Morrison case, which just says this is okay. So there's a point. What's going to happen here? I mean, predictions are worthless, obviously, but there is a real distinction between the CFPB structure and the structures that were authorized by the Supreme Court in independent commissions in the past. And that is this. CFPB has one director. And every other time, except for the special counsel, which is a kind of a different situation, every other time in every other agency where the Supreme Court has said this is okay, it's been a multi-member commission or agency. And the idea being, at least you have some sort of cross accountability and you have more of a sort of a groupthink here, and you're not subject to the whims of simply one person. And that is a distinguishing factor here. And if I had to predict, so we know how Justice Kavanaugh is going to come out. I mean, there's no, at least he's not going to validate, I think, the structure. Would he go further and argue, are there justices who would argue that independent commissions are simply a violation of the separation of power? There is an incredibly large body of law out there that suggests that independent commissions and agencies are an unelected fourth branch of government and that they're not constitutional under our Constitution. Will the court go that far? I doubt it. Justice Roberts is an incrementalist. He's an institutionalist. He respects stare decisis. So I don't think they'll have his vote on that to go that far. But it wouldn't surprise me if you see at least Kavanaugh and maybe someone like Alito or Justice Thomas kind of signing on to that notion that we should be thinking about broad reformation of modern government as we know it, the disappearance of independent agencies. The other really interesting factor I'll just conclude with is, okay, so what happens? So let's say they decide that that this agency was essentially unconstitutional. The second question that they're going to be deciding is whether or not this restriction on the president's right to remove is severable from the rest of the DoddFrank Act. If they decide that it isn't severable and that it is unconstitutional, the whole CFPB could go down. And does it go down prospectively? Does it go down retroactively? Does it call into question all the enforcement actions and the rules that have promulgated? Who knows? And even if they find that it is severable and it can go forward as an agency, but these particular restrictions on the president's right to remove the director are unconstitutional, what does that mean? Pretty clear what it would mean going forward, but what does it do to regulations, enforcement actions underway, or adjudications that have already happened? Again, completely unclear. Likely somehow to be addressed by the court. I don't think they're going to want to leave that hanging for future courts to try to figure out. But lots of big questions created by this case.
Well, that is a quintessential example of a cliffhanger. We are right at the end of our hour. I want to thank you all for attending. I'd like to thank the panelists for their contributions and wish you all happy Thanksgiving. See you in December. Thanks a lot.